Copyright is the group of rights that applies to a work. A work could be a screenplay, a composition, a master recording, something that some element of creativity has been put into. Think of your copyright in a work as a bundle of sticks. You can give away a stick, you can license one, you can sell one, transfer ownership to it, you can make copies of it, you can show it to the public. Copyrights are the different things you can do with your work. Applying copyright to music, it allows you to copy your music, record it, re-record it, license it to someone, have your music used in a film or a video game, or performed publicly. It also allows you to monetize all of those rights. Copyright exists in a work as soon as you put it into a tangible form. That means getting it out of your brain and onto the paper, or recording it, or displaying it to the public. What can't be copyrighted is an idea. There is no copyright in an idea. But once you've put your idea into that fixed form, once you've written out your music or recorded your song, your copyright already exists and you already own it. To protect your copyright, you can register it with the Canadian government under the Canadian Intellectual Property Office. Registering it acts as evidence of when the copyright existed and who owns it. Once the copyright exists, you get all of the benefits under the Copyright Act granted to copyright holders. Copyright exists in a work for the lifetime of the author of that work, plus 50 years after they've died. If you've written a musical composition, your copyright in that composition exists for your lifetime until you die, plus 50 years. In the United States, the term of copyright is different. It's the life of the author plus 70 years. Same for the EU. If you're looking to see if copyright has expired, please be sure to check what jurisdiction you're looking for those rights in. Grand rights, or dramatic rights, are the right to use a musical composition in a dramatic production. It can be a bit confusing using the phrase dramatic production, but under grand rights, we're talking about stage productions like musical theater and opera, or other live performances revolving around a dramatic subject. Grand rights are different from non-dramatic rights, sometimes called small rights, which are used for other performances of compositions. Small rights, non-dramatic rights, include synchronization rights, the right to use a composition in an audiovisual production, public performance rights in other capacities, concerts, live music in venues, use of live music in a non-dramatic fashion. Don't get confused by the names. Grand rights versus small rights, dramatic rights versus non-dramatic rights. One isn't better than the other, one isn't more important than the other. What you need to think about is what kind of production are you putting on? What are you using the music with? Is it in a musical or an opera? Or is it a concert? Or are you using the music in a film? That determines what kind of rights you need to clear. A work is in the public domain when either its copyright term has expired or if the author chooses to put their copyrighted work in the public domain. Sometimes authors choose to grant their work to the Creative Commons, allowing for anyone to use the work however they choose. That grant has to be explicit, though. In terms of the term of copyright, in Canada, the term of copyright is the life of the author plus 50 years. It could be longer in other jurisdictions, like the US, where it's the life of the author plus 70 years. Pay attention, though. If a work has multiple authors, the copyright won't expire until the death of the last author plus 50 years. A work in the public domain means copyrights no longer attached to it. You don't need to seek permission from a rights holder in order to use that work. For example, copyright has expired in the works of some of our most famous composers, Bach, Mozart. You can use those works however you choose. However, be careful, Copyright will still exist in other people's recording of those works. When looking at translations or folk songs or arrangements of older works, the copyright in the original composition may have expired, but there's copyright in those translations, in those recordings, in those arrangements. You'll still need to seek the permission of the owners of those translations and arrangements and recordings before using that version of the work.
Do you need to know the difference between the different type of licenses? Either you need to know the difference between the different types, or you need to have someone very close to you whom you trust, who knows the difference between the different type of licenses. It is important and essential actually, because you need to know what kind of authorization you will need for your project to make sure to avoid any troubles later when it's going to be too late to find solutions. There's a million different type of scenarios in terms of media, authorization, licenses, tarif. But just to give you an idea, you have the synchronization license. That is when you want to synchronize a music on a visual. You have the reproduction license, that is mechanical license also, when you want to copy some work into physical support, like a CD or a DVD. You could also need public execution license, which is to perform in public. But these are only 3 out of 1,000 different possible scenarios. Because of the dynamic of the business and the law that is changing sometimes, or the regulations that are changing, maybe you knew the answer yesterday and it changed since then. So make sure you always confirm, even if you think you know exactly what you need, make sure you always confirm the information. Don't be shy to ask questions. I've been doing what I do for almost 15 years now, and I still have questions every day of my life. It's normal not to know everything. It's normal to find it confusing. So make sure you ask questions as much as you need. Make sure you surround yourself with people whom you trust. And don't hesitate to refer to experts whenever you have a question.
A master recording is owned by the person who's created that recording. That's not usually the musician or the artist performing, but instead the producer or the sound engineer. You might hire one of these individuals to create a master recording for you. In exchange for money, they'll grant you the rights to the master recording. But make sure that grant of rights is written down. If you don't have a written document saying that the master recording has been granted to you, you won't own it. Private copying is exactly what it sounds like. It's making a copy of a copyrighted work for your own private use. In terms of sound recordings, it includes burning a CD or making a copy of a tape, making a mixtape. This is all private copying, and it's perfectly legal. It's allowed under the Copyright Act. It is not allowed, however, to make copies and disseminate them to the public or earn money off of them. That is not private copying. Private copying is allowed under the Copyright Act due to private copying levies that are applied to the media on which the copies of recorded music go onto. Blank CDs, blank tapes, even your iPod. The private copying levy is built into the price of those items as a royalty to music rights holders to compensate them for the private copying of their copyrighted works. Neighboring rights are the public performance rights of performers and sound recording makers in master recordings. Neighboring rights are usually divided into 2 equal parts: the artist's right or the performer's right and the maker's right. Much like public performance rights in compositions, neighboring rights are generally administered by collective rights societies. In Canada, we usually look to Resound. Those collective rights societies will administer neighboring rights on your behalf, collect royalties and fees that are owing on the public performance of your master recordings, keep an administrative fee, and pay the rest of the income out to you. How to know whether you need to obtain rights for something, for a piece of music you're using in a project, or a film clip, or a picture. Ask yourself, did I create this item myself? Or did I purchase this item? Did I license it? Or did someone make it for me and grant me the rights? If the answer to those questions is no, you did not create the item yourself, you did not license it, you did not purchase it, you need to clear the rights. You need to look and find who the owner of the copyright in that item is and get the rights from them. To obtain the rights to a copyrighted work, you need to find who owns the copyright to that work. It might be the original creator, it might be a music publisher, or it might be a larger company. You need to contact that individual or that company and ask them for a license if you only need to use the work for a short period of time or for a specific use. Perhaps you need to purchase that copyrighted item, but regardless, you need permission to use that item in whatever your project is. Sometimes a copyrighted work might have multiple owners. There are different rights involved. For example, if you need to license a piece of recorded music, someone owns the master recording, someone owns the composition. The artists have rights in it as well. You need to get the rights from each of those individuals on similar terms. If you need to use the item for 6 months, all of those rights holders need to grant you the rights for 6 months. Obtaining rights to, say, a piece of music can be a lengthy process. You'll be chasing a lot of people for a lot of different rights, and it can be quite expensive, especially if you're looking to obtain rights to a more popular work by a well-known artist. Give yourself time, have a healthy budget, and do your best. The consequences of not obtaining rights to a copyrighted work can be severe and expensive. The owner of the copyrighted work can send you a cease and desist notice instructing you to stop using their work in your project. They could get a court order for an injunction, which forces you to stop using their copyrighted work. Or they could sue you for copyright infringement in the federal courts. A successful case of copyright infringement can have significant monetary damages applied to it, including statutory damages under the Copyright Act of up to $20,000 per infringing use of a copyrighted work. If you have used a copyrighted work in your production or your project and only realize it after the fact, you should still get in touch with the copyright holder. Ask for permission to use their copyrighted work. It's not as preferable as asking permission beforehand, but it's still possible that you could get a license. It might be more costly and you might lose some of your own rights in exchange, but it's better than going ahead without permission at all. To protect your work from being copied, the only guarantee you have for it never to be copied is for you never to publish it. But that's not really an option. So when you are putting your work out there, you can include a watermark on documents indicating that it belongs to you and it is copyrighted. In an email, you can state that this item is copyrighted by you and is for confidential purposes. You can have the recipient sign a confidentiality agreement or a non-disclosure agreement. The key is indicating that your work is copyrighted and that that copyright belongs to you. And in sending the work to that person, it is not intended that they may copy it. If you find that someone has copied your copyrighted work, contact a lawyer. There are things that lawyers can do to stop the copying, to prevent further copying, and to guide you on what your options are. We can send a cease and desist letter, which tells the copier to stop what they're doing. A demand letter in case their copying has been commercialized and monetized for you to receive that money that they've earned. Or at worst, we can help you file a claim in the federal courts for copyright infringement.
Can you restrict the territory for whether it's a recording, exploitation, or a broadcast of one of your shows? So let's start with the show itself. The only way you can really restrict the territory in terms of the broadcast of a show is by the IP address to really see if you're in the right country or not, or maybe the credit card address that is related to the account that paid the ticket itself if it's a paid online show. Still, it's quite complicated to do because you can whether fake an IP or use a VPN or use any other way to kind of mimic the fact that you're in a country even if you're not. And it's pretty hard to go smaller than a country. So to go to a specific city, a province, or a region, it's kind of hard to do. So you better normally do your broadcast available to everyone in a country, and that's probably the most you can restrict or maybe control who can see one of your shows. As for a recording, if you're working on another territory with a record label or a management company or even a publisher, sometimes they're going to ask you to restrict their territory so they are the ones that are collecting the revenue on this specific territory. So when you're pushing your music or entering your music on through a distributor or an aggregator, you can always restrict certain territories that are the ones that they are in. So you can say, for example, I want my music to be everywhere in the world except in the UK or in Brazil, and therefore they're going to be the one that are going to enter on their side when they're going to put the recording on their distributor's channel, that they are collecting only their country itself.
Performing rights organizations, or PROs, are organizations that act on behalf of copyright holders of compositions. They administer the public performing rights of those compositions to the public and grant licenses for the public performance of those compositions. A copyright holder can sign up with a PRO of their choice, and they grant the PRO the exclusive right to administer their public performance rights to the public. Third parties that want to publicly perform a composition will contact a PRO for a license and pay a fee for that license. The PRO collects the money and, after keeping an administrative fee for themselves, pay out the rest to the copyright holder. There are different PROs all over the world. You only need to sign up with one. In Canada, we operate with SOCAN. In the United States, there's ASCAP or BMI or CSAC. In the United Kingdom, there's PRS. Most countries have their own PRO. Many PROs around the world operate reciprocally with each other. If your music is played in the United Kingdom, PRS will collect the public performance license fees and pay them to SOCAN if that's who you're signed up with. You do not need to be a union member to sign up with a PRO. You don't have to sign up with a PRO at all, but it's a really helpful benefit. Signing up with a PRO doesn't cost you any money. The PROs make their money by collecting an administration fee on all of the royalties they collect on your behalf. Sound Exchange is a collective rights management organization. They're responsible for collecting performance rights on digital sound recordings. They're like a PRO, but for the master recordings. They collect something called neighbouring rights. Similarly to the PROs, they will collect income and royalties owing to you on your master recordings, and after taking an administrative fee, will pay you out the royalties. You need to sign up with Sound Exchange for them to act on your behalf.
Qu'est-ce que Creative Commons? D'abord, ce qu'il faut comprendre, c'est que Creative Commons, c'est un concept qui a été inventé par un avocat qui s'appelle Lawrence Lessig. Et Lawrence Lessig se posait la question, comment adapter le droit d'auteur à l'ère numérique? Il faut dire que le droit d'auteur a été inventé en réaction par rapport à la presse imprimée en 1710 avec le statut d'Anne. Et c'est un principe qui prévoit le contrôle de la copie. Or, Lawrence Lessig s'est dit, avec Internet, qui est notre nouvel environnement numérique, comment faire pour pouvoir appliquer ce principe-là d'autoriser la copie? Alors que l'environnement numérique est un endroit où est-ce que, par défaut, il faut copier. Alors, Lawrence Lessig s'est dit, est-ce que Internet est un environnement adapté au concept du droit d'auteur? Et la réponse était non. Alors, il s'est dit, on va adapter le concept du droit d'auteur à l'environnement numérique. Donc, dans un contexte comme celui-là, il a inventé les licences Creative Commons. Et toutes les licences Creative Commons, il y en a 6 que je peux vous expliquer aujourd'hui, toutes ont une chose en commun, c'est que c'est possible de copier. Ça prend acte que sur Internet, il faut pouvoir copier. C'est la nature même d'Internet. Donc, on part du principe que le tout droit réservé, le droit d'auteur, celui qui nous tombe dessus du ciel quand on vient au monde puis qu'on est créateur, dès qu'on crée une œuvre et qu'elle est présentée au public pour la première fois, le droit d'auteur nous appartient par défaut. Et qu'est-ce que c'est ce droit d'auteur-là? Ça veut dire tout droit réservé. Appelons ça le copyright. D'un autre côté, 50 ans après notre mort au Canada, notre droit d'auteur tombe dans le domaine public. Appelons cela le copyleft. Et donc, entre le tout droit réservé et le aucun droit réservé, si on veut, Lawrence Lessig s'est dit il y a une multitude entre le blanc et le noir, il y a une multitude de teintes de gris qui existent. On peut faire toutes sortes de choses. Le tout droit réservé, ça veut dire moi, en tant que créateur, j'ai tous les droits, donc toi, en tant qu'utilisateur, tu n'as aucun droit. Ça veut dire que l'utilisateur doit demander la permission constamment. Et si on veut être capable de communiquer à quelqu'un qui peut remixer, partager, faire de l'argent avec notre chanson, bien, à ce moment-là, on peut lui dire. Alors, la licence de type « buy » est la plus permissive. Ça dit « fais ce que tu veux avec mon œuvre tant ou aussi longtemps que tu honores mon ego, que tu dis que c'est une chanson qui vient de Guillaume, par exemple. » Ensuite de ça, il y a d'autres types de licences qui permettent de pouvoir copier l'œuvre, de pouvoir l'adapter, la remixer, s'amuser avec, d'avoir du fun, mais à des fins non commerciales. Ça veut dire quoi? Ça veut dire que si jamais vous remixez la chanson de Guillaume et que vous avez eu bien du fun, maintenant vous voulez la commercialiser, vous devez demander la permission à Guillaume de vous donner le droit d'utiliser la chanson à des fins commerciales, dans des pubs, des films, des documentaires, d'en faire la vente ou quoi que ce soit. Et avec les licences Creative Commons, il est presque possible de faire du copyright en disant ben, en fait, on est sur Internet, donc vous pouvez copier, mais à des fins non commerciales, sans pouvoir adapter l'œuvre, sans pouvoir la remixer. Pas touche, elle doit rester telle qu'elle. Et vous devez nécessairement citer constamment l'auteur original lorsque vous en faites usage. Donc, il y a plein de possibilités que l'on peut voir dans le petit tableau que vous allez trouver dans les crédits de cette capsule, qui illustre en un coup d'œil toutes les possibilités qui existent entre le tout droit réservé et le aucun droit réservé. Et ça permet de communiquer à la collectivité ce qu'ils peuvent faire et ce qu'ils ne peuvent pas faire avec votre œuvre. Je terminerai en disant, faites attention parce qu'il y a certains types de licences Creative Commons, notamment les licences qui ne contiennent pas le NC, qui disent que l'usage que les autres peuvent en faire doit être non commercial. Et lorsque vous cédez, dans le fond, à la collectivité le droit de faire de l'argent avec votre œuvre, ça veut dire que autant vous que les autres peuvent le faire. Mais, dans ce contexte-là, vous ne pouvez pas céder à la SOCAN, DR, Soproc ou etc., le droit de percevoir en votre nom les revenus générés par les usages commerciaux parce que vous l'avez déjà donné à la collectivité. Donc, c'est important de bien choisir votre licence. Et je terminerai en disant encore qu'il y a possibilité de jouer avec les licences Creative Commons. Vous pouvez avoir 90 % de votre catalogue, de toutes vos chansons qui sont sous licence copyright, tout droit réservé, mais quelques-unes qui, elles, sont données un peu au pâturage, si vous voulez, de manière accessible en levant toutes les restrictions sur ces chansons-là. Ça vous permet de vous faire connaître. Je connais des créateurs qui, eux, leur musique est utilisée dans plus de 26 000 capsules web sur Internet parce que certaines de leur musique est disponible dans la librairie libre de droit de YouTube. Et donc, il y a énormément de gens qui n'ont pas de maudite scène puis qui ne paieraient même pas pour de la musique de toute façon, qui utilisent leur musique dans leurs vidéos de mariage, etc., sur YouTube. Mais ils le font dans un contexte où ils sont obligés de citer que le nom de l'auteur original. C'est une belle manière de pouvoir se positionner un peu partout et de gagner en notoriété, et puis d'en garder quelques-unes pour usage commercial. Donc, il y a possibilité de jouer avec toutes ces licences-là. Il y a des stratégies à développer.